October 22nd, 2024, Planning Board meeting to order. Karen, if you could take a roll call, please.
Ms. Claudia Bogan?
Here.
Mr. Jim Callahan?
Here.
Mr. Kevin Donovan? Absent. Mr. Dave Edmonds?
Here.
Mr. Rob Klein?
Here.
Carolyn Turner?
Here.
Chair Bob Darty.
Here. Before the meeting begins, please silence your cell phones and note that this meeting is being recorded. First thing on the agenda is an A&R lot line relocation plan of land for 12 Mon Drive and 37 Bruno Terrace.
Good evening, Attorney Bob Knight from the office of the Main Street. I'm here representing the, and just on a land swap, it's not anywhere substantially affected square footage of the lot. The lots are pretty big as they are, almost 20,000 square feet. There's still zoning compliant, that's the key. The owner of number 12, Juan, he just wants to add to his deck, but he doesn't want to have to do the variance route, and there's so much land up there. So they felt that this was the better way to do it, so they keep everything in compliance. Oh, the TV guy just told me. Oh, sorry. Step over.
Okay, any questions of the applicants? Seeing none, do we have a recommendation?
Yes, there is a recommendation for the board to endorse this particular lot line relocation plan.
If there are no further discussion, I'd make a motion to endorse the plan. Approval not required.
Second.
Motion by Claudia, seconded by Jim. All those in favor? 6-0 carries.
Thank you.
Up next is the Sherman Terrace subdivision update on progress towards completion.
Good evening, Mr. Chairman. For the record, Attorney James Giuliano Law Group, 607 Main Street here in Woburn, on behalf of Sherman Terrace LLC. If you remember, a few months back, we were discussing a resolution to the matter that was relating to basically the turnaround that was located on Sherman Terrace in between 1 and 3. I do have with me here tonight Arthur McElhaney, who is a partner and part of manager of the LLC. If you have any questions, basically what came out of that last meeting is Mr. Charest was attempted to get somebody to fill in for him to use machinery to sort of scrape that area down and rebuild. Unfortunately, he was unable to do that. He can't do that. He's still going back and forth trying to figure treatments out for his back that he really is, I wouldn't say immobile, but pretty close at this point. Again, Mr. McElhaney can speak a little bit more towards that if you have any questions. Right now, we have spoken to the neighbors on a good note. They are amenable to anything that we need to do at this point, so there is no adversity from the owners of Lot 1 and Lot 3. We have a revised easement plan should the board endorse something outside the box as of keeping the turnaround where it is, vis-a-vis whether it's, keeping it with the grade and same fill or different fill. But that's sort of where we are at this point in the game. Certainly we can answer any questions, and Mr. McElhaney can answer any other questions on behalf of the LLC if necessary as well. So I do have copies of the revised plan if anybody would like a copy of them, but I didn't want to disseminate it just yet if depending on what the board advised.
Okay, any questions? Jim?
So we last met on this application. It's my understanding that we're going to revise the turnaround area with the right materials and revamp it once we get someone to do the work. In addition to that, as a representative, you're going to seek an easement for the proper turnaround location. Has that component been done, the easement?
The easement, I have a rough draft of the easement that, again, depending on how the board advises us at this stage in the game, the easement is drafted, it's in rough form. I do have a revised easement plan, again, that I have on hand if the board wants to take a look at it. But it just all depends on whether the easement that is in the original plan is going to stay, or if it's less intrusive to move the turnaround and create a new easement. Either way, we're certainly able to do either one of those. But I didn't submit any easements because as far as the location goes, I don't think we're confirmed yet, where the board would like to go with this, so.
Have you been in conversations with the neighbors?
Yeah, so as I mentioned, we have spoken to the neighbors as recent as, I think, probably yesterday. Mr. McElhaney discussed it with them, and again, they are fully on board with whatever we need from them at this point. If we have to move the easement over, keep the easement, there's a retaining wall, move the retaining wall, but they are totally amenable and favorable to whatever we ask for of them as of right now.
Okay, thank you.
Anyone else?
Bob?
Yes, Clyde.
Council, we have I guess, a completion date that expires the end of this month, right? And I'm not sure what the request is for us tonight. Clearly, this is the last meeting before the subdivision expires, so what is it that you're seeking us to do tonight?
I guess some guidance to see if there's two options at this point. Put back and extend, or some other option to put back the original turnaround, or if it's, like I said, it's less invasive to keep it, but move the easement, which we're fully prepared to do either one of those. I do have rough easements if the board is inclined to keep the existing turnaround, again, without being intrusive and sort of ripping all that out or keeping it. So again, I'm just looking for a little bit of guidance at this point where my client wasn't able to do what we were required to do at this point, quite frankly.
So, the way I understood that presentation was that this is not a simple request simply to extend the completion date, right? Because I'm assuming that's part and parcel of what you're here for tonight, because you have a subdivision that's about to expire. The request is for us to give you feedback on what we would like to see as a solution. Is that right?
So we can, like I said, do one or two things. We can keep things the way they are. There is $188,000 of money that's still left from the bond. Or again, if the board isn't inclined to either sort of, I guess they have the authority to extend that completion date with a vote. But if you're not able to or willing to do that, I guess the other alternative would to use bond money to finish it or complete it the way that the board seeks fit. So I guess that's up to the board. I'm just...
Okay, so what I'm understanding is that we can either give you more time to fix the problem with easements. Like, as my memory is not 100% on this project, but
Yeah.
what I do remember about it is that the thing that was built is not the thing that we approved. And in order to make the thing that's built what we approved, there needs to be some easements generated, right? Some fixing of the right of someone to be on a particular piece of property. And until those easements are fixed, you can't fix it. Am I on the right track?
Yeah,
as to
so
the
just,
deal?
and I apologize if I'm unclear with it, but correct. So we have two options. One, the board tells us to put back the turnaround where it was supposed to be on the plan that was submitted with the subdivision.
Mm-hmm.
And there's no need to do anything with the easements because the easements are already drafted and recorded where they should be according to the original plan. Or option two, keep the turnaround where it is. It's stable, it's all grown in, it's there.
Mm-hmm.
However, the easement area is incorrect at this point. The easement, to fix an easement it would take me probably a week or two to get signatures, record it. So it's not troublesome at that point, but those are the two options. So keep the turnaround, that is there, it's lush, it's grass, it's stable, and just re-record, or I should say, confirm more easements with the right location as to where the turnaround is as of right now.
Okay, because I believe when we were here in May, I think the issue was we didn't know whether there would be the cooperation required to make option 2 feasible. That's my memory. You're nodding at me.
That's
Is
correct.
my memory
That-
correct?
that is- your memory is spot on, and I can assure you.
It's not always, which is why I'm asking it in the way I'm asking
Yeah.
it. Okay. So you're coming before us today, and you're saying, hey, planning board, option 2 is viable. It's viable because I have an agreement or an agreement in principle of all affected parties to execute an easement document, right?
100% correct.
Okay. So, speaking for myself, under the circumstances, I would go for option 2 if what you're saying to me is that that's a feasible option. I can get that done in a week, right? Then this whole subdivision would be completed. Am I right?
That would complete the subdivision at that point. Once that easement is recorded with the correct turnaround, we are completely done, and there's no need to discuss any further, correct?
I see. And you have draft documents, but you didn't know what we would pick, so you didn't, didn't feel it was appropriate to submit them.
Correct.
So I mean, if what you're looking for tonight is a direction, hopefully, as a planning board, we can provide that. This has been going on a really long time, and there doesn't seem to be a point to let it drag out any further. So I just wanted to be sure, though, what you're asking.
Agreed.
If you're coming before us in October of 2024, saying, hey, I was here in May, when I was here in May, I didn't know whether we could get cooperation. I thought we could, but I couldn't represent. And so now you're here saying, I can represent, if you as a planning board vote to, I'm trying to think what the vote would be, because in essence, we're voting to modify our subdivision approval, right? And so my question back to you is, technically, how did we accomplish that, right? And this is maybe through the chair to John. If we wanted to say, okay, it was built in the wrong place, we're going to overlook that, we're going to modify our approval to make that be okay, and he can come in with the easements necessary to make that legal, right? The actual property owners who have the right to give the easement are, in front of us. Would we do that as like a all-in-one?
Yes, exactly. And you are recollecting everything in pretty much proper format. We left it with you in the spring that, and I remember saying this at the meeting, that the physical improvements for this way were established, and there really wasn't a need to dig anything up. Rather, the best course of action for the board, in my opinion, to consider is for the easements to be established, or easement, as long as you can get the parties to agree to the easement itself. So you would have a plan, an amended plan for the board to consider. You would have the easement signed off by all parties of concern. We would probably send that easement doc and the plan off to the city solicitor for his input. And once he was satisfied and all parties of interest were satisfied, signed off on, then you would submit those two products to the planning board for a vote.
Correct. And then I would record, subsequently, if that got approved, I would record that at the registry.
Yeah, and I would say that the modified plan could probably qualify as an exhibit, a recorded exhibit plan to the easement or easements.
I have no comment on that last one, but my comment to that through the chair is that sounds like a good idea. My question is, does this need a whole new public hearing?
I would think not, but we can leave that up to the city solicitor. The easement can make reference to the actual approved plan. And then the plan associated with the easement, it would be referenced in the easement document that the exhibit plan would supersede the previous subdivision plan.
Okay, I see that, but there is a modification of a subdivision plan that has been approved by the board. And the only way I know of that the board can legally modify a subdivision plan is to have another plan come before us for a public hearing, the abutters are notified, and we modify it. Am I incorrect on that?
Well, the only exception would be if the board determined it was a minor modification to what was approved. If the board determined that it wasn't a minor modification and that it required a public hearing, that would be the board's purview.
Okay. And what is the definition of a minor modification?
Anything you want it to be.
Yeah,
I see.
Anything reasonable.
so through the chair, Mr. Director, I think this would fall into section 11. So basically, there are some examples of what a minor modification is in the ordinance. And I would tell you probably most boards in the city would say that something like this would be considered a minor modification. There's differentiations between minor and major, and the director is correct. So if it's a minor modification, it doesn't need to be published. Board of Appeals started doing this, City Council does it.
Yeah, I'd give you an example, if I could, Mr. Chairman. So a major modification would be, obviously, just for the sake of illustration, they got approved a 500-foot-long cul-de-sac roadway, and they wanted to modify that to 1,000 and double the lot sizes. That would be a major modification, obviously, and you'd have a new public hearing, new plan, blah, blah, blah. But you're not expanding upon any pavement surface, everything's in place. The only thing that's really needed is an establishment of easement for all parties of concern to sign off on, and if they're happy enough to do that, then we should be able to handle it as a minor modification and call it a day.
I would agree with that, yeah.
So I'm just looking back at our subdivision rules. For some reason, the one I have is the 2005 Woburn Planning Board Land Subdivision Rules. Karen, is this the latest one?
Yes, I believe, I'm not sure our subdivision rules and regs, have a minor modification provision. I think Section 11 in the Woburn zoning ordinance, has a minor modification, reference, but I don't believe our subdivision rules do. I think it's just, Section 11 of the Woburn zoning ordinance.
So what I'm reading, because, we got rules, we should know what they say. This is section 9, under approval, modification, or disapproval. And it seems to be 9C. It says, revisions to an approved definitive subdivision plan shall be subject to all requirements for a plan application, including notification of abutters, hearing notice advertisements, public hearing, contents, fee payment, and other requirements. Revisions will be subject to the subdivision rules and regulations in effect at the time of the application for revision. So that's my memory of the rule. I'm looking through the rest of the rules for a minor modification provision.
Through the chair, I think this would be similar to what we discussed with Baker Way, when they had the problem with the wall and the driveway and the grass strip. Remember that? We had to do they had to refile, and we had to do a modification.
Yeah, that's my memory,
Hearing.
that there wasn't a sort of minor issue, minor out for them. I'm continuing to look. Now, query whether there should be. That's kind of another story at this point in time, right?
They're probably, it's been a long time since I've read our rules and regulations, even though I authored quite a few of them many years ago. Most cities and towns do have a minor modification provision, and a lot of times it's left to either the city engineer or the town planner to approve the minor modifications. A lot of times, just in-the-field changes that don't really call for the need or the public attention. You're gonna change the location of a catch basin, or a water line location. Something to that effect is a in-the-field change. Usually it's a minor modification, it doesn't call for a public hearing. Again, it's the judgment of the board, and as with any subdivisions, it's it's a prerogative of the majority of the sitting quorum of the planning board at a meeting, whether they want to.
So I'm going to make a suggestion. And the suggestion is, I personally think that there should be a minor modification type requirement in our rules. You, sir, have not yet filed for anything. You're just coming before us kind of informally, right? You have a plan, it's approved, you need more time to complete it, and sort of technically that's why you're here, right? And you're in discussions with us on a known issue with your subdivision that we're trying to be as cooperative as possible in the public interest, as well as all parties' interests to fix. So, my suggestion is that we amend our subdivision rules to provide for a minor modification requirement. And we can do that relatively quickly, can't we? Because that's just one provision that we're adding to our subdivision rules. And John, I'm sure you have a model somewhere, quick, that you could come up with, right? Because technically, if we were a board that abided by its rules, I can't find a way to do this in our current rules. And I'm not comfortable with that, because once we start down that path, that can be a slippery slope. But it doesn't strike me as asking a lot or being a big deal to amend them. There are rules. We can put an agenda item on the next meeting, right? It says, public notice, we seek to amend our Woburn Planning Board land subdivision rules and regulations to add a minor modification of an approved subdivision requirement with a definition, right, as well as a procedure. And we can enact that at our next meeting. And then if your feedback tonight is, you know what, if we think you have the ability to meet that definition, maybe at that point you would then apply with your easement in hand, right? And say, hey, I need to modify this subdivision. I need to make it conform to this new easement. Then you file your document under our then currently existing subdivision rules, which is actually what the rules say today. And we vote on it under our new rules. How does that sound?
That sounds very good. I
Okay,
think we
so
can do
that's
that.
just my suggestion. I'm just one member. Board members, that's one way of handling this. How do people feel?
Jim?
I have a different recollection of the previous meetings. Mine is that there was a retaining wall put on the adjoining property without permissions from the subdivision approval. It encroached on this turnaround area, which limited the area configuration as designed. The developer's engineer came in here. Initially, he said he had a red line drawing, and then he presented it to us. 2 weeks later, he said he could make the configuration work, but the product that was used is not H20 loading approved material. And that is why it's being rejected by their engineer, which is for heavy-duty trucks, particularly fire trucks. The area of the turnaround is not so much the issue as it is the proper materials to be used, which requires scraping up the grass and sand material, some 6 or 8 inches of that area, and replace it with the plastic grid material of the right depth, and then restoring the area. I don't understand where this is going, and I'm a bit frustrated, quite honestly. But that's my recollection of it. As far as modifications, I'm looking to get this resolved the way we left it last May, which was do the work, get someone in there, use by hand, not a great area, and restore it the way it's supposed to be.
All set? Anyone else? Okay. I just throw my 2 cents in. I recall what Jim is saying, is that we had set the completion date to October 31st, anticipating that this would all be done by then. And then now here we are, October 20th, or whatever today is, that, I said what
22nd.
the day was. Today's 22nd, lost 2 days in the last hour. And you're looking for direction from us as to what to do. I thought at the last meeting, we pretty much gave direction as to what was to be done.
Correct. So, again, that work was not done, so we can, again, going back to the two options, keep what's there with the capacity of the soil that's there, with the structure that's there, with the retaining wall that's there, or option two is to go back and scrape everything down, rebuild everything with the correct turning radius, with the H20 material, and do it that way. So I guess that's, again, here's what we know. As of right now, other than the fact that we have spoken to the neighbors ad nauseum and we have their approval to do sort of within reason anything, meaning move that easement, don't move the easement, there's nothing that has been accomplished despite many efforts. Through our part, again, we've had many conversations with Mr. Charest. Here we are, in short. I don't want to sugarcoat it. Here we are. So I guess if the board doesn't want to give a recommendation, we can sort of go the avenue of what member Les Bolden said, and we could just apply for now what we think is a minor modification and see if the board establishes that we've met the criteria for that. If not, then we would have to, obviously indirectly, rebuild what was originally planned. Which I guess, is sort of proactively asking that tonight, I guess, at this point in the game.
Mr. Chair?
Yes, Jim.
Please explain to the board how the applicant's engineer brought to the attention of this board about the H20 loading, which is gonna now have settlement of trucks of any size go on it, including cars, is gonna hold up, and any one of these two neighbors can have justification to come back looking for this board for relief. Because the city engineering department and DPW and Public Works did not bring it to our attention. It was your engineer that said this would not sustain it. So we had a professional engineer who's a design engineer for this project, told us it would not work. How would you like us to approve something knowing that it's gonna fail?
I guess I would answer that by saying that in reality, where we have a situation where Sherman Terrace is, I don't think a fire truck or a 32,000-ton truck is going to, or pound truck is going to use that turnaround as designed and approved to begin with. So the turnaround now is able to handle typical cars, sedans, pickup trucks, so on and so forth. And I think the engineer, and I will state that if we're going to put multiple axle trucks, 32,000 pound weighted trucks, no, it's not going to handle it. You need an H20 material and system that will hold that. Again, going back to what I just said, I think in reality, and I could ask Superintendent Duran if in reality is somebody going to put a truck down there and turn around, or are they just going to back in or go forward and back out? Same with the fire department. I don't know. I don't know the answer to that. I can find out the answer to that, but I guess we're just asking for, deference in reality. Like in reality, if they weren't going to turn around anyways, it was approved that way and they're never going to use it regardless. That would be my question and comment.
Chair?
Yes.
Not that. So we rely on your design engineer to design the project with his drainage calculations and his knowledge and experience that he's gained over the years. And when he comes to us and tells us that this is lacking and will not sustain, we should ignore that component of his design?
No, I think drainage is a,
We should rely on your opinion or the opinion of a city employee?
well,
They want to put their stamp on it. I know Mr. Duran and other people in this city have a professional engineering stamp. If they want to do that, I'd be more than happy to stand behind it personally. But That's why we hire professionals, like attorneys, to represent you. Okay, we look for their proper guidance and professionalism, right? And it was your guy that brought it to the table, and he told us it would not last.
So through the chair, if you're talking about drainage, yes, I agree.
I'm using it as an example.
Okay. No, obviously, we still have to get, if we were to revise these plans with what is there now, they have to be stamped with accurate depictions of drainage, stability, et cetera. If that can't be met, then again, going back to what we started with in this meeting, is that the board can accept or reject that.
I knew I'd find it if I went looking. So in section 6 of our present rules and regulations, that's administration. Section 6A, variation, strict compliance with the requirements of these rules and regulations may be waived when, in the judgment of the board, such action is in the public interest and not inconsistent with the subdivision control law.
John, where is that?
That's section 6, administration. It's a catch-all phrase, but
Okay, in our subdivision rules?
yeah, and what it allows for is in the judgment of the board.
Oh, okay, I see
It's in
it.
the public interest. You know, the board uses this phrase mostly when it concerns waivers to the subdivision rules and regulations. But it also means in that one sentence that any strict compliance can be waived by this planning board if, in the judgment of the board, it's in the public's best interest. You know, the thing is, back in the spring, and to be respectful of Mr. Callahan's opinion, this is such a minor roadway. It's constructed. You know, this isn't Montville Avenue. You know, it isn't 1,000-foot or 2,000-foot cul-de-sac, you know, requiring, you know, a real plan for the fire department to go in and turn around and everything else. They're gonna be going into the street, fighting the fire and backing out of it. There's no area in that whole neighborhood for any type of proper firefighting apparatus to be able to turn around. You go deeper into this roadway, you're going up a steep grade, and you're backing into people's yards, driveways, and everything else. It's a hodgepodge. It's not a modern-day subdivision by any means. It's an old subdivision. Least amount of pavement, least amount of turnaround, and it works. And it reflects pretty much, you know, 60% of the composition of Woburn roadways and turnarounds. You know, try going up to Eastern Avenue, the end of Eastern Avenue, which I'm very familiar with. My brother Kevin's lived there for probably 60 years. There's no turnaround. You get houses upon houses, and you know what? If the fire trucks go up there, they have to deal with it. You know, and that's the way it is in much of America. It's not a perfect scenario for anybody to be able to turn around when you get down these old roadways.
Dave?
How long has this been going on? 4 years?
I think my brother counsel filed this in, yeah, maybe close.
So
3
we've been
years.
having this discussion for 4 years. And there was always a reason why they couldn't do it, or it couldn't be done, or it didn't happen. And now you're saying, let's just forget it. And I have you know, I mean, we put a lot of time and effort into the original, and this was a big discussion item. Of all the things that we talked about in the subdivision, this was probably the thing I remember the most. And now we're saying, never mind. And I have a hard time with that. But aside from that, if we were gonna do anything, you run out of gas on Thursday. So what would you want us to do to extend whatever we need to extend to come up to end up with some sort of a decision? I mean, is it gonna be done next month if we say, no, you gotta do this? Or is it the season over, so now we're waiting until next May?
Yeah, so through the chair, I think, I would never say to just forget it. I think that was just an option that the board has, is to say what's there is built, it can accept it, but that's why we're here to sort of, I wouldn't suggest that, that's your only option, and that's what I'm forcing the board to do, but it's an option. So, leave it at that. But the board, again, the director can elaborate a little bit more, but the board can decide if this is the end of the road, then I guess they have the option of, you have the option of taking the bond money and finishing the project if that's the end of the road, that this is it for the applicant and we don't want any other avenues. That's what the money's for. That's what the city does with the bond money if these situations, come to a head. We're just suggesting, look, we have two options. One is sort of move the easement, keep what's there, or two, based on our meeting in May, scrape it down, put the H20, rip everything apart, take the wall down, make it to what was there before. Again, I don't know how long that could take. I can't speak on behalf of Mr. McElhaney and Mr. Charest, but those are the options.
Claudia?
I think for us, there are two practical options. Option one is to take the bond and put the work on the city to finish it. I think practically that's the option. If in the judgment of the board, it's important to make the actual thing on the ground conform to what we approved. Option two is to utilize the, well, I won't call it minor modification, but Director Cashel rightfully pointed out that strict compliance with the requirements of the rules is in our discretion. I don't think option three, which is continuing to give the applicant more time, under the circumstances, and certainly, no aspersions or judgment on the developer. My understanding is that it's a sickness and physical issue. I don't believe that that's a viable option because I don't hear from the applicant that they're confident that just given more time, they can do what this board, if indeed it wants, which is to scrape this down and fix it. So I think as a board, we have an obligation to the public as well as the applicant to make our minds up. Are we okay enough with what is on the ground to approve a modification, an easement document, and let this be over? Or do we feel strongly enough that we're going to take this $188,889.50 and put the onus on the city to finish it? Because I think the third option, which is continuing to give more time and then, have the meeting where nothing happens, I don't think that's actually viable. I think we need to just face the facts. So I'm certainly interested in, having either a vote or a discussion where we come up with the idea that one or the other of these options is acceptable to us. I think we need to decide and get it going because as Dave rightfully pointed out, we've been having this discussion for 4 years and that's probably long enough. So that's my opinion. Thank you. I'm set.
Thank you, Claudia. Anybody want to comment? Carol?
Yes, so if we were through the chair to accept the change as a minor modification, allow the developer to obtain easements, realistically, how does that timeline work if the completion date is October 31st? So that would be, they would have to be filed with the registry by then?
This,
If-
through the chair.
Through
Yeah,
the
we-
easements?
We would have to, before concluding tonight, it would be in the board's best interest, out of council, that the board vote to grant an extension and figure out, when can we put this thing to bed as a possibility? Is it before Christmas?
Oh, I think if you guys meeting in November, I would say that's a possibility, because again, it's all my work, meaning I don't need to, get in a backhoe or do anything. It's work that's pretty much all done at this point. So I would say probably by Thanksgiving, and if that does not coincide with the meeting dates, probably the next meeting.
And to that, Mr. Chairman?
Yes.
If I could, I would suggest the first and only meeting in December. And if you're lucky, they might be in the Christmas spirit.
And I would say, that is, I will emphatically tell you that we would, at that point, have everything submitted to the director and the planner well in advance for review of city solicitors' eyes as well. I don't want to throw it at the meeting. I don't think that's fair to anybody.
Sounds like a plan.
Jim?
So the other issues were the curbing was removed and we were receptive to putting in a spike, corner bound instead of a stone bound. Has that work been completed and accepted?
I have not spoken to the engineer regarding that. I think either one of those, I think either one was from the original approval. I think that, from my recollection, would not be an issue if, I think the question was, if we put down what was approved, it was something that would probably be kicked up with a plow or something, or a car, but we can meet that requirement regardless, so I think that,
That's what we discussed last
Yeah.
May, was instead of putting a stone bound there, that would be hit by a plow, which was brought up by yourselves. If we could put in a railroad spike, would that satisfy the requirements? We all agreed and gave you permission to do that. Now, 6 months later, we don't have that stone bound or that bound set in 4 days to expiration date. Now we're looking to probably extend it 4 to 6 weeks, and we haven't had that work scheduled or implemented and accepted by the city.
through the chair, I think that we can probably accomplish.
I'm at a point where I'm beyond deliberation. I'm looking to give them a 6-month extension. That's my proposal. To try and resolve all matters to the original state per their engineer's design and layout with the proper geogrid and the railroad spike. That give them to what, May of 2025? Find a contractor to do the work and do it. I don't think it behooves the city to take the work on. I don't think it's a good practice. I don't think there's any benefit to the city, and I think that's my option I want to go with. Otherwise, there'll be a no vote for myself.
Does that include the turnaround also
That
to
is
be
the
done the
turnaround.
way it's
Modify the
supposed?
turnaround to what the applicant engineer provided to us at the last meeting with the dimensions, the depth, the product that was supposed to be utilized, and a railroad spike stone bound, deleting the granite curbing that conflicted with the stone bound.
Is that a motion?
That is a motion.
Okay. And that is to extend the completion date till when?
6 months, I believe that's what, May 22nd? Right?
That's April.
April 22nd. Make it 7 months, May 22nd. Give them a month of construction season.
All right, so we have a motion on the table right now to extend the completion date to May 22nd, and for them to conform to everything that was in the plans originally.
Second for discussion.
Second by Dave for discussion.
Through the chair. Jim,
Yes.
you want them to complete the project as it was originally approved by May of next year.
As it was modified.
as it was modified, but,
Correct.
right.
Which are minor dimensional changes for their engineer to meet the square foot and length requirements for the turnaround with the right product for the loading of the trucks.
All right. And in the event that we're looking at this again next May,
And I'll be
Because
going-
that
I'll
is
be
a
going with
possibility.
bond- I'd be going with the bond removal.
then we would, you're saying at that time, we would
At
consider
that
taking
point.
the bond.
My personal vote would be to vote for the bond.
Any other discussion? All right, we have a motion by Jim, seconded by Dave. All those in favor? All those opposed? 4-2 carries.
So through the chair, just for clarification, I don't think, and I would seek the director's advice on this one, I don't think that would procedurally ban us from still filing for a minor modification. If that minor modification does pass, then obviously that would, I believe, take the vote and nullify it, I believe. Again, I would defer to the directors. Sorry, Mr. Cashel. I can look into it too, but I don't think anything precludes anybody from filing a major or minor modification. I mean, we're in no different position than 4 years ago, I guess, at this, you know what I mean?
Yeah, but we would need to vote, the board would, to allow for the rescission of the approval, the previous approval. Then you could refile after that in any manner you'd like to.
Yeah. Again, I just looking at the dissent a little bit, it's fine. We won't move forward at this point with the vote taken with any sort of revised easements at this point, because we have direction with the vote, and I guess we'll bring this forward in May of 2025. Thank you.
Thank you. Okay, up next, Planning Department updates. First item on there is the board's next meeting will be on Tuesday, November 12th, 2024, right here. John, you had a couple of other things on here?
Well, we do have, as an agenda item, if we'd like to, go over the edits that were provided for this meeting concerning the proposed procedural rules governing the planning board.
Yep.
So we have a lot of comments involved, and, we could actually start our work on this at this point in time, since we did get a lot of homework input from the last meeting.
Anyone want to start discussion on that? Everybody see the changes? Minor. The minor modifications of the draft.
I think we have a lot of discussion with, built into some of the lengthy comments, so we really have to get into it relative to drafting the final language. And also taking into consideration the court case that Claudia provided for everyone, Barron versus Colenda, and that was a Massachusetts court case. And people don't have to be as cordial as we'd like them to be, basically. But we could try to set some ground rules and see if, they would stand in court if we were so inclined to have an unruly situation take place. And not that it ever would, but, just trying to think about everything that could happen at a planning board meeting and being prepared for it.
Claudia?
I'll start. So there's lots of potential changes in here, but I'm just going to zero in on page 7. And the whole purpose that I started this project back last summer was when Barron versus Colenda came out I read it and I realized that in essence, one of the only potential guardrails that we as a board have if a public speaker has commentary that, might be not as civil or as courteous as many folks would like. The only guardrail on that is a time limitation. Every other thing that was in the opinion as a potential limitation was either rejected outright or, had its own, potential issues. And so on page 7, under receiving public testimony during hearings, 4.5F. The current language says, in certain circumstances, the number of people wishing to address the board during a public hearing may be so great that they cannot all be heard within a reasonable amount of time. In this case, the chair may limit such speaker to a specified amount of time, i.e. 5 or 2 minutes, and require that further testimony from those speakers be submitted in writing. And the comment I had at the time was, if we don't do it every time, right? If we don't do it every time, then it's going to look like the only time we're going to do it is if there's, issues with if either individual members or, there's some concern about the subject matter, something that would end up being a content restriction. And so that was my comment, that should we as a board just adopt a rule that says every speaker in public hearings has 5 minutes, say. And most speakers, in my opinion, don't go that long anyway. So I doubt very much that the chair, who would be enforcing this, would have a bunch of times they'd have to say, oh, your 5 minutes is up. But my comment was, if we don't do it all the time, then the only time we're going to do it is in a situation where we could be called on the carpet to, oh, this is really a content restriction in disguise. So that's like the major issue for me in these rules, is that's the way I can address the court case with a content neutral. Every speaker that comes before us in front of in a public hearing context has 5 minutes, say. And no one has to think very much more about it, because in that 5 minutes, they can say kind of, whatever, they can exercise their right to public discourse. They can exercise a very robust right to speak their mind. And that's what our law is. I accept that. That's fine. But the time restriction is sort of meant to put some guardrails around that, in my mind. So that would be my main comment to the draft, which is, why aren't we saying in every case you've got 5 minutes? Most of the time we don't have a room full of people where even 5 minutes times 50 keeps us here until 1 o'clock in the morning. That hasn't happened in many a year. So that's my main comment, and I'd like to hear my colleagues discuss that, because that's the heart of the reason why I started this project. Thank you.
Dave?
So I get the time limit, but do they have to be restricted to the topic under discussion, or can they just get up and start talking about anything?
I think that restricting the topic under the discussion in a planning board hearing, like, we don't have, the way this particular court case came up was in a public comment period in a Board of Selectmen meeting, where after their meeting was over, they had some period of time for public comment. That's not our case. When we have public hearings, they're about a topic, right? And so that can certainly be in our rules, that the public hearings that we as a planning board have are on a topic. The speakers are limited to that topic, and they're limited to 5 minutes. And so the question I think you are asking, Dave, is, why do we need 5 minutes if we have an express limitation? Hey, this is the topic. Is that what I'm hearing?
Yeah.
Okay. Yep, fair point.
Carol?
Yes, so on my comments, I pretty much agreed with what Claudia had to say and also what the case said. And I think that the way it's currently written, it says in this case, the chair may limit each speaker. I don't think that's a good idea. Again, limiting time or imposing time limitations on a project-by-project or case-by-case basis is not a good idea. We don't want to be in that position. We don't want to be exercising discretion as to which applications may be allotted additional time periods. If it's 5 minutes, if it's 5 minutes across the board, it needs to be consistent. And I put that in my comments as well.
Thank you, Carol. Rob?
So I noted the same thing, it has to be consistent, I think. The only thought I came up with is if, you know, and again, this is kind of a lot of admin work, but if we were to put a metric on it to say if there were, say, 30 or 40 plus people, some metric, then maybe they're restricted to 2 minutes, but that was just kind of the notes I had. Like, I thought if we do enforce a time limit, it should be every time, we should kind of run a timer every time someone's speaking, and that maybe you can impose a metric of, again, if this whole room's crowded to whatever, 40 people, you could cut it down to 2.
Yeah. I think it's so infrequent that we have situations like this. And, you know, I revert back to the good old days. And esteemed member of the city council, John McElhenney, would always say, you know, this is America. You know, we're supposed to have the right to speak our piece. I mean, I just don't think we really need to get into time limits. We, you know, it's so infrequent that we have a project where people are going to come up to address the board and spend more than, you know, 5 minutes. Usually it's a minute or two that somebody wants to comment about traffic or, you know, any other issue of concern. You know, except for myself, most people are up and down in front of that mic pretty quickly. I'm sorry, but sometimes I get long-winded.
The other question is that, so let's say we do adopt a 5-minute time limit. Is that the first time they get up?
Good
So
point.
they could get up a second time and do 5 minutes? You know, do we need to have something like that in there? The other thing too is looking at the case that you had sent us that we could take a look at there. I believe that even if we had that in there, we would, if somebody ever decided to take us to court because of that, we would lose. You know, like, who are they to begin telling me I only have 5 minutes that, you know, because the case that you had given us, it was a pretty, it looked, I mean, it was written, it was, I don't know, 18 pages or something, but it seemed to be pretty simple, is that somebody belligerently got up and was, whatever, being rude and stuff like that, and they asked them not to be, and they got shot down. The courts upheld the fact that the people can get up and say what they want to say and be belligerent about it while they're up there, and there's nothing you can do about it. I would see putting a time limit as the same thing. Like, how can you put a time limit on something? Not that I don't agree with it, I just don't think it would hold up. And I also, in all the years that we've all been here, I think we're putting something in there that has never been an issue. It's never, you know, I don't know if anybody's gone longer than 5 minutes. It seems like it sometimes. Sometimes it seems like, you know, they're up there for 20 minutes. But really, 5 minutes is a long time to get up there and speak about something. Most people are probably 2 minutes, minute and a half, which to them, because it's not easy to get up there all the time, that minute and a half seems like forever. So I just don't know if, not that I disagree with the concept, I just don't know if it would ever actually hold up. Limiting time frame. Claudia?
So the way that I read the case is a content-neutral time restriction on speakers is the only thing that will be held up. Because it is uniformly applied, it is not at all dependent on what the speaker says. The speaker can spend 5 minutes telling each of us how great we are and what a wonderful job we're doing, or the speaker can spend their 5 minutes with, you know, a complete lack of civility. And the reason that I thought, if I was chair, that I would want a guardrail of time is that that is literally the only way I think I can think of after reading Justice Kafker's decision to limit what could be, you know, a very potentially traumatic experience for those people who are here as either audience members or who are up here as, you know, citizens who are on this board trying to do, you know, the best we can for the city. There's no other way other than saying your time is up, sir or ma'am, to get somebody to stop with what could be characterized as verbal abuse. That's it. And if you don't have that, then as chair, you are subject to whatever you do being sued in your personal capacity, FYI. That was the part that kind of got my attention when I was chair. So that was the reason for the time limitation. Not that people speak too long, they don't. Our community has been very, they're using their public participation very wisely, in my opinion, as is your opinion too, right? Our community uses their public participation very wisely, but it's literally the only guardrail that I think would stand up.
So in a sense, it would give the chair some control over a uncontrollable meeting.
Right. And when I was chair, that seemed like a good idea to me.
Excellent point. Rob?
So I saw it and read it the same way, and I was thinking the same thing. My only comment to that would be, we would like have to run a timer, even, you know, again, people probably don't speak that long, but just in case if we were to go to court and they wanted to look back on previous meetings and we let someone peacefully speak for 6 minutes completely on accident, that would just be one commitment we'd probably have to make, you know, depending on who would, if you would run it or the chair would run it, or, you know, we would just have to be vigilant of running a timer when people speak.
Time. Get one of those things that the sand.
Yeah, the hourglass.
5 minute sand thing that you just turn up and down.
But I don't want to, I mean, if folks aren't worried about it and the cure is worse than the disease, that's legitimate, right? That's why it takes all of us to make our rules. Everybody has to agree that, you know, it's worth doing. I'm just pointing out that as chair, when this decision came out, I quickly realized that were something to happen, there was no way of really mitigating that, you know, without the potential liability. So.
And
Hold on one second. Yes, Dave.
And I just want to remind you, the last time we spoke about this, I mentioned at the Department of Education where I work, when they have their monthly meetings, they have a 5-minute timer. And they come in and the people make whatever the presentation is, and I've heard some things that made me go, wow, what does that have to do with us? But they got their 5 minutes and ding, and everybody just respects that. They know right up front that they have 5 minutes and they respect it, and it works. And they've only done that since this whole thing happened.
Interesting.
I mean, they had something before, but it's become really concrete.
John?
Yeah, I just want to add a little bit that, you know, dating many years back, this hall has seen plenty of contentious projects that have been submitted, a lot of opposition from the residents. But the city of Woburn has always exhibited, you know, a small town feel to its public hearings and, you know, allowing people to say what they want to say and voice their concerns. I've also witnessed public hearings in larger cities that are very controlled, impersonal, unfriendly, you know, basically not allowing the general public to say their piece. And, you know, it's not a friendly place to, you know, witness. And then I've worked in a lot of towns where their towns, their communities, you know, residents mean something. You know, businesses mean something. But, you know, everybody has a fair shot to say what they want to say and present whatever their evidence is. You know, and I feel much more comfortable in those type of settings. And those types of settings, you know, for the most part, do a much better job of creating, I think, more civility. And, you know, we're a community that really cares about what the people have to say and what their concerns are. You know, and I don't think we don't run into so many situations that, you know, we have to have this time clock going like Congress has. And, you know, in Congress, that's used as a hammer, a sledgehammer, against public discourse. It's ridiculous. You watch what goes on in Congress, and, you know, no wonder people don't like the way Congress conducts itself. You know, it stifles people from having their free speech, that we're all supposed to be about free speech, you know, but they don't give anybody the right time of day down there to listen to, you know, a different opinion. So I don't think, you know, we really need to indulge ourselves in worrying about 5 minutes' time. So that's my opinion.
Okay. So we've discussed that little aspect of it. Any other part of it that anybody read, thought should be different or changed?
Again, I'm okay without having a time limit,
Okay.
but again, if one is included in there, I think it needs to be across the board and be uniform. That's really my only point. And again, I think what happens with the more lengthy hearings are more infrequent. That's why I'm a little less concerned as well, understanding the director's point.
Okay. So with that in mind, we'd like to get this drafted up at some point. I think we should take a vote as to who wants to put a time limit in there. I think that the 5-minute, yes,
Can I interrupt to make a suggestion?
I haven't.
What if we have one or two, or whoever would like to draft, rework this paragraph and submit it in 2 different ways and have everybody look at it and give it some more thought? I think it's an issue that's important enough to consider and make sure we're all in agreement or majority. And sometimes if it's written, you know, the way we might propose it and it's in front of us, we may have the same opinion or a different opinion.
That sounds great.
And I'd be happy to be involved and do that and
Okay.
or participate in that undertaking.
That will, yes, John?
Yeah, I just have one more big point to make in the content of these procedures. Section 3.5, public comment during meetings. This is a really important paragraph in here, and I don't know how many board members are really familiar with this, but when the board has a public hearing, those are open to public input, because it's a public hearing. But when the board is holding a meeting, and the item on the agenda is not a public hearing, but it's a matter of developing, for example, planning policy. You're talking about things that have to do with economic development, subdivision control, stuff like that, but it's not a public hearing. Those types of meeting in the forum for those meetings, it's not a matter of receiving public input. And, that's the board conducting its business, and it's not a public hearing. It's a meeting of the board discussing policy and possible changes. So that's the distinction in that paragraph. There were quite a few comments in regard to it and really what it means. But the board members realize that, we only receive public testimony during public hearings and not during the course of conducting our business relative to developing, our subdivision rules and regulations or, any other matters that are non-public hearing items on our agenda at a meeting.
Carol?
So, on section 3.5, I understand what you're saying, John, and I think the way it's written is confusing. I feel like we're talking about a public hearing and then we're not, and then we go back to allowing comments prior to a public hearing.
Yeah,
So I just think it needs to be clarified.
Yeah,
I agree.
and throughout these 11 pages, there's a lot of sentences that try to, jam in as much information with all these parenthetical phrases that you just get lost. And they just have to be reworded, into understandable English, so that would help.
Okay.
Yeah. I'm all for that.
Yes, Claudia?
That's, I think, Carolyn's idea with regard to the last paragraph, that perhaps we need to see something in writing to decide which of two potential options we should choose. That probably goes for 3.5 as well, because it is confusing. The intent, I think we all understand the intent. Everyone who sits on this board knows that there are plenty of meetings that we have and hold that are not public hearings. And there are sometimes members of the public that wish their input, and, having rules about that, I think, is important. But one of my comments to this, so to finish that thought, I think, this is one of the ones that could be rewritten and then shown, right, before anybody makes a thumbs up or thumbs down, to make sure that this encompasses what we think it means. But one of my comments here reminds me that there is a provision in here regarding the holding up of signs. And this came about because this actually happened to Tina, our former planning board director, in a prior job. And the question on the table, I guess, that I was thinking about is, well, if there is not a public hearing, so the public is not invited to speak, is a nonverbal communication of holding up a sign something that is also prohibited. So it's in everything is always in the definitions, and we as lawyers kind of get, roused about that, but it's actually kind of true. What is comment, right? So I just throw that out there, not necessarily so that, we put a definition in here with regard to signs, but just as an example, right? That, some of the words we choose have maybe unintended consequences, so.
And Mr. Chairman?
Yes.
I think a goal of this whole procedure is to be as careful as we can relative to our duties and responsibilities, statutory and local provision-wise, is to keep the city out of harm's way regarding any libelous situations. I was at an MAPC meeting last week, and there were 6 CEO types in this board, and 3 of the communities were going through very expensive litigation and findings against their communities, in the millions of dollars. So that's another thing we really want to make sure of. And I know Claudia and Carolyn, you know, we have the good fortune of actually having attorneys on the planning board that can help guide us in that regard. But, you know, we don't want any procedure that would, you know, lead to litigation, because the world is filled with it. There's a lot of people out there that take up a lot of their time trying to find litigious means by which to survive. So.
And if I could just briefly, through the chair, add to that, as I had mentioned, I think before, the Barron versus Calenda case had to do with members' personal liability. So it's the city, of course, we're always trying to protect, but my impetus, and I'll be transparent about this, in starting this process, was seeing the personal liability and thinking, well, you know, if that's me and I'm chairing this meeting, I want to know how to keep myself out of trouble. And I would think our chair and our vice chair would have currently the same interest in that, too.
A very, very serious matter, because I've been involved with people being personally sued for what they've said at public meetings, and it's not a fun thing to be in the middle of if you can avoid it.
See, we're all about you.
No, you're out just thinking of me, I appreciate it. Because I don't say anything anyway, so.
Well, you can imagine why I'm concerned.
All right, John, on your updates, there was a couple of good things on there. You would, something you said we wouldn't have to discuss at this meeting, but about the zoning amendment regarding accessory dwelling units.
Yes, and, you know, Karen brought this to the board's attention, and it is a matter that we're going to be dealing with public hearing-wise once the amendment language is drafted sufficient format that the council will schedule the public hearing. They will request our, you know, request the planning board to actually hold its public hearing date for a recommendation to the council. If you're not familiar with this legislation that was recently passed, it actually replicates exactly what was passed in New Hampshire with accessory dwelling units about 10 years ago. And the sky didn't fall in, you know, the world didn't change. You know, these are expensive propositions for people to consider, you know, adding an accessory dwelling unit to a structure. It really, most instances, it has to have an overriding factor, you know, unless it's new construction, and you're building that into the cost. But to add on an accessory dwelling unit to your property, it's a sizable investment. What also involves with this is, I think it's pretty well accepted now, the tiny houses in your backyard, and those are allowed within this statute change. And the building inspector, the city solicitor, myself, other people involved with local government are trying to, you know, figure out, you know, what's an appropriate setback, taking into consideration that our minimum lot size is 12,000. There are tons of lots that are, you know, much smaller than that. You know, we're going to probably have a decent amount of proposals for mini houses or accessory dwelling units within existing garages, self-standing garages. There's probably going to be a lot of zoning business created by this. Site plan review, I question that completely within the content of the statute. If a project is allowed by right, or use is allowed by right, and it has to do with a single-family dwelling or a duplex dwelling, by statute, that's the complete exclusive jurisdiction of the building commissioner to deal with. So I don't know how you bring a single-family house or a duplex issue, proposing accessory dwelling unit as site plan review. That, you know, that doesn't make any sense, but in New Hampshire, it was resolved once they figured everything out, that accessory dwelling units are allowed by right. They should not be required, or should require site plan review or special permit. Special permit days are gone in accordance with the statute. I think the one question about site plan review and involving the planning board for an accessory dwelling unit, I think that's gonna fall flat in its face too. Because again, that's the jurisdiction. Single and duplexes are the jurisdiction of the building inspector. And we don't play a role zoning-wise. That's my big take with it. We'll be dealing with this probably in the not too distant future, in a public hearing, format. There's also,
John, can I ask just a quick question?
Sure.
Just to make sure I understood. Even though the law itself references site plan review, it says if applicable. And your point is that you don't see how in our city, under our zoning, site plan review is applicable to something like this. And so if that viewpoint ends up carrying the day, then this is an entirely building inspector-centric workload.
Right.
That's right.
Yeah.
Okay, just
And the
making
lo-
sure
and
I
the-
understood.
Yeah, and the logic for that, I really got deeply involved with this issue over the last few years. Site plan approval, again, site plan is not even mentioned in the state statutes, okay? It's a planning tool. There are court cases in Massachusetts and other states having to do with site plan. But in its raw form, site plan review leading to planning board approval of such is the technical delivering of the site plan that the board approves with reasonable conditions. That's deliverable to the building commissioner. It's not even an appealable decision at all for any court to decide or anything like that. The building commissioner's decision to issue a building permit having to do with the site plan, and that being appealed, whether he issues it or not by the aggrieved party, that can be appealed, but only to the ZBA. ZBA decisions lead to court proceedings. But site plan review is not an appealable decision, even to the ZBA. So those are recent cases of land court. And I was just involved with an extensive one up in Georgetown. But it's pretty well defined now, the limitations of site plan. So what I'm getting at is like, well, if the use is allowed by right, and statutorily, the building commissioner has exclusive jurisdiction with single-family and duplexes, how do we get involved with those particular uses relative to an accessory dwelling unit that's allowed by right? I mean, it's basically a waste of time. We're not gonna deny it. We're not gonna have the authority to deny it, and our decision is not even appealable. It's not even considered an administrative decision. It's just our input. It's no more than me commenting to the city council on a special permit. Whatever I comment is not an appealable decision or recommendation or anything. It's just, that's all it is. It's only worth the paper it's printed on, but that's it.
Okay, so just to make sure I understand, the planner and the planning board director are going to put together a proposal for an amendment to our zoning that comports with state law on this Affordable Homes Act.
Yeah.
And as a preview of coming attractions, you're saying that that language that we're going to be looking at is going to provide that these homes, these accessory dwelling units are as of right, and it will be subject to building inspector / ZBA / then court process. That even though as a planning board, we're setting forth this proposal, we're actually not in the chain of custody, so to speak, of these things.
In
Do I
all
have that
In all
correct?
likelihood, with more thought put into this, that'll be the end result.
Okay. All right.
In my opinion.
Okay. All
but-
right, good luck with that, guys.
Yeah, yeah. And plus, the guidelines haven't come out. They're promising guidelines. They haven't originated. I haven't seen those yet. You know, so are we putting the cart before the horse? Karen, when you're reviewing this, have you found a deadline that we have to enact?
If we don't, change our zoning by February 2nd, 2025, whatever the state statute says will be
Yeah.
applicable in Woburn.
Yeah.
So if we wanna make, some tweaks to it that we can under the law, we have to do it before February 2nd, 2025, which I think is a Sunday, so it'd be that Monday.
Yeah. Litigation will result no matter what, with some cases. It's not gonna be crazy amount, but there will be litigation that results from this law being passed, and some people not getting what they want, and, you know,
Okay.
stuff like that leads to litigation.
But it certainly makes sense for Woburn to get out in front of it.
Right. Well, we have to, now
Beautiful.
that it's been clarified. It's a February due date.
Excellent. Well, Karen, thanks so much for bringing that to our attention.
Jim?
One point that I'd like to make to you folks while you're looking at it, that you may need to clarify the difference between accessory dwelling and accessory building. Because I believe accessory building currently is a 4-foot setback. Okay, and you probably want to define that there are no living quarters of any kind of accessory structure.
Yeah, well, believe me, setbacks are a major concern, and, you know, who knows what state might come up with as far as a setback of an accessory dwelling unit in someone's backyard is going to be. You know, are they gonna leave that up to the communities to decide, whether it's 20 feet, 5 feet, 30 feet, 4 feet? You know, we don't know yet. Yeah. This is gonna be, it's going to be, it's probably the biggest piece of legislation that's passed, without a lot of forethought, if I could throw that in as a comment.
Okay, we have draft minutes from October 8th.
I'd make a motion to approve the draft minutes as submitted.
Second.
Motion by Claudia to accept the draft minutes as written, seconded by Dave. All those in favor? 6-0 carries. Do we have anything else coming before us?
You know, one other item.
Yes, Jim.
In that legislation that was passed that included the accessory dwelling units, there's also legislation in there, Claudia and Carolyn, I don't know if you, or anybody else in the audience, have heard about this one, but the lot merger doctrine that's been in place since the 1970s, that's no longer standing. So that if you have or owned 2 lots and they were merged involuntarily, dating back to 1970, or that's when the law really came into vogue, you're entitled to lot separation and the buildability of that second lot, providing it meets minimum criteria, 5,000 square feet, 50 feet of frontage, and you can meet your setbacks without having to go to the ZBA, but, you know, that's also legislation that was passed as part of this, statutory package. So, it's on the premise, they did this in New Hampshire, and, it's a taking without just compensation. And Massachusetts just adopted what New Hampshire has adopted dating back 15, 20 years ago now. And it has to do with another one of my brothers. 5 lots.
Okay,
5 lots.
Claudia?
If there is no other business, I would make a motion to adjourn at 8:29.
Motion by Claudia to adjourn at 8:29, seconded by
Second.
Dave. All those in favor? 6-0 carries.